Hi everyone, welcome back to FLAC. Hope you all had a very productive reading week, and we are very excited to be relaunching our panel series, starting with this week's discussion on Thursday on the topic of sex crimes in Ireland. We have a great panel lineup for you, including Aidan McQuaid, who is the former director of Anti-Slavery International. This is the world's leading anti-slavery organization and the oldest international human rights organization. Aidan is currently a consultant in ethical leadership and has shown strong dedication among the topics of human rights, international development, and humanitarian responses. Next up, we have Hazel Catherine Larkin, an activist, author, and academic. She holds BAs in psychology and sociology, an MA in sexuality studies, an LLM in international human rights law, and is currently working on a PhD in DCU focusing on transgenerational trauma in regard to women and child sexual abuse. Hazel was also the first person to take a civil case before a criminal case had been concluded in this country. And Shane Connedy is a research assistant at Maynooth University in the law department focusing on criminology. So we have a great panel, very excited to have them all speak. You don't want to miss it. Again, it's this Thursday, March 25th.
I've been asked to speak about sex crime in Ireland. I think it's important to say from the outset that this is a subject upon which I'm barely a student, let alone an expert. However, I have spent the past number of years dealing with in some detail with the issue of trafficking, including for sexual exploitation. This has included research in Albania, Nigeria, Bangladesh, and Myanmar, and dealing with cases in the UK of young women trafficked from, among other places, Albania, Vietnam, and China. So I'd like to talk a bit about some of the key things I have learned from that and some of the implications for law and policy. First, it's important to remember that sexual violence and trafficking for sexual exploitation are not matters solely related to women and girls. Men and boys are also trafficked in this way and subject to sexual violence, sometimes as a weapon of war or terrorism. But it's also undoubtedly the case that the majority affected are women and girls. Second, it's important to understand that poverty, particularly amongst discriminated against groups such as Dalits in South Asia, or migrants in Western Europe or Southeast Asia, their poverty is a major driver of trafficking, including for sexual exploitation. In Chin State in Myanmar about 18 months ago, on the border with China, I met local activists working to stop families selling their daughters for a few $1,000s for forced marriage in China. In Cox's Bazar in Bangladesh, families of Rohingya refugees living in the mud of the camps were also reported to be selling their daughters for forced marriage and into local brothels. In both instances, there appeared to be a choice being made by desperately poor families that their daughters would be sacrificed in order to earn enough money that the rest of the family could better survive. There is no use judging these actions, dreadful as they are, if we stand idly by. And while I know Trócaire has raised these issues in Ireland, by and large we do stand idly by, because in the main our aid programs and policies do not actively engage to reduce the debt and other forms of vulnerability that render those individuals and communities most susceptible to exploitation by traffickers. All of us are different, but I think there are a few elements which all human beings share. We all want to be loved. We are all afraid of dying, and we all want a purpose. Often it is the nature of trafficking to take these most human of traits and use them as leverage to exploit and enslave people. Many of the Albanian women whose cases I have dealt with in the UK over the past couple of years have been trafficked into sexual exploitation by men they have fallen in love with. This, the so-called lover boy technique, is described by the international anti-trafficking organization La Strada. At the start, they note, the recruiter shows an impeccable behavior towards the victim, flattering her with false promises, love statements, and presents. When a woman falls in love, she shows much more trust and accepts to follow him even abroad without asking too many questions. For the women who reach the destination, the reality turns out to be absolutely different from everything they previously imagined. They're forced into prostitution against their will. Researching in Nigeria at the end of 2019, I spoke to young women and men who also dreamed of better lives, this time from work overseas rather than from finding love. Often encouraged by their parents, they would set off overland through the desert to Libya, where they hoped to take a ship to Italy. Of course, those who transported them across the desert never had any intention that they should get that far. Instead, if their passengers survived the perilous journey across the desert, they would be sold immediately into slavery as soon as they crossed the Libyan border. Men to forced labor in construction and agriculture, women into brothels. It's an unsettling truth that it is the best impulses of humanity, the desire to find love, the desire to have a better life for oneself and one's family, that render these young people so vulnerable to trafficking. But that is the brutal and tragic reality. Now, if I ever meet a victim of trafficking, no matter how horrific their story is, it means that they are amongst the lucky ones. They're the ones who have managed to escape and found their way home, or they're among those who have found their way to a conscientious lawyer to help them navigate the hostile environment of immigration policies that mean many may prefer to deport them rather than identify and protect them as victims of dreadful violence. It's important to understand that trafficking for sexual exploitation tends to be but one strand, if generally the most egregious, in the operations and practices of trafficking networks and individuals. But from understanding this strand of exploitation, we can see that just as international aid policy and practice must be put on a firm anti-slavery footing to diminish the risks of trafficking for poor people, so too domestic law and policy must be put on a robust human rights foundation that prioritizes identification and protection of the victims of trafficking over any anti-migrant fetish that some sections of the population or the political elite may hold. Trafficking, including for sexual exploitation, is not just a criminal matter. It is also one of poverty and abuse of human rights. Unless this is clearly understood, any response to it will be an anemic one.
Hello, I'm Hazel Catherine Larkin, and I want to thank the team at GCD's FLAC for inviting me to share a few words with you on sexual crimes in Ireland. Academically, I hold an honours degree in psychology, an MA in sexuality studies, an LLM in international human rights law, and I'm in the middle of my PhD, where my focus of study is women and child sexual abuse. But perhaps of more relevance is my own personal lived experience. I have a history of child sexual abuse, incest, trafficking for the purposes of sexual exploitation, and domestic violence. I have experience of reporting to the Gardaí, both for myself and in my capacity as a support person for others, including minors. Over the years, I have learned that there are gaps, there are areas where we need to improve, and there are also areas where there has been huge improvement. To start with the latter, I want to acknowledge the outstanding work that is being done by the National Protective Services Bureau, headed up by Detective Chief Superintendent Declan Daly, who is honestly one of the most compassionate and understanding men I have ever met. On account of the work that Declan has done, there are Gardaí in every station in Ireland who are trained to work with people who wish to make statements around sexual and gender-based violence. Victims then are routinely assured that they are not blamed, they are not at fault, they are not responsible for the crimes perpetrated on their persons. I have seen Gardaí work with victims on their days off, accompany victims to court, really listen to victims and treat them with huge dignity and integrity. And this is, of course, exactly how it should be. Where our judicial system is not covering itself in glory, however, is at the later stage, when files meticulously prepared by detectives and sent to the DPP with a strong recommendation for prosecution do not result in a trial, never mind in a conviction. It's easy to see why victims are reluctant to report. I mean, what is the point in going to the Gardaí and enduring hours of reliving horrors and the trauma that that involves when we know that our meticulously made and taken statements are deemed by the DPP as not warranting prosecution? In the few cases that do make it to court and where prosecutions are secured, the sentences are woefully inadequate. While we have laws around rape and other crimes of sexual violence, including the recently enacted legislation around coercive control and around image-based sex abuse crimes, the latter commonly known as Coco's Law, they are useless instruments if they are not used. In effect, a law that is not effected may as well not exist. I'm always reminded of the legislation enacted in 1980, which saw rape within marriage become a crime, but that this law, which has been on the statute books for more than 40 years, has only resulted in one prosecution. We need this to change. We need our laws to be effected, to be put to work for those affected by crimes of a sexual nature. We need victims to feel safe coming forward and safe in the knowledge that their bravery in so doing will not be for nothing. It has been noted by many victims, and not just myself, that the focus of the criminal justice system is on the criminal. And maybe that's why it's not called the victim's justice system. But the rehabilitation of perpetrators is deemed paramount. Their comfort, safety, protection, and education are all considered when they are in prison and indeed afterwards. But what of the victims? They are left abandoned by the state, the system that has used them to secure a conviction and then does nothing to help ensure their rehabilitation, comfort, safety, protection, and education. Like so many things, the problem is multifactorial, and therefore the remedies for the problem must likewise be multifactorial. Our laws around rape have not evolved enough from their origins. As you know, rape was initially viewed as a crime against the man who owned the woman who had been hurt. It was seen that the crime, the rape, damaged the goods belonging to this man, and he needed and deserved restitution. While the legislation now views crimes of a sexual nature as crimes against the person who is raped or otherwise sexually assaulted, the system is still adversarial. The system still does not understand or make allowances for the way in which traumatic memories are recalled. It's not a linear process. It's not an immediate process, and it's not necessarily even a process that takes place in chronological order. No allowances are made for the fact that in traumatized people, certain things like the face of a clock or a certain smell or a curtain flapping in the breeze or a particular phrase may be seared on the memory of a victim, but other aspects are not easily or even possible to recall. Instead of being met with understanding, victims are treated like liars, and they are blamed by counsel for the defense for their own assaults. We need this to change. We need barristers, solicitors, and judges to inform themselves of the impact trauma has on people, how it changes people's reactions, how it alters the structure of people's memories. We need trauma-informed practice in our courtrooms. We need to tell victims that they matter, that they will be heard, they will be listened to, they will be understood, and they will be treated with dignity and respect. We need the golden threads of care, compassion, and concern for our victims to be carried right through the judicial system, from the moment of first disclosure to the moment of final sentencing and beyond. Only then can we truly say that we are a victim-centric system that prizes justice over law.
Hi everyone, my name is Shane Connaty and I am a tutor and research assistant at the Maynooth University Department of Law. So as a research assistant, the main project I'm working on is one that's related to juvenile sexual offending with Dr. Tom Quigley. So both juvenile and sexual offending are kind of two of my main areas of interest in criminology and criminal justice. So today I'm just going to be talking a little bit about image-based sexual abuse. the kind of harm that it has caused, the extent to which it has caused harm, particularly in the last kind of 6 to 12 months in Ireland, and the passing just last month of the Harassment, Harmful Communications and Related Offences Bill, and what that kind of means for the offence of image-based sexual abuse going forward, and for sexual offending in general as well. So firstly, the first kind of issue to bring up about image-based sexual abuse is the use of the term itself. Image-based sexual abuse, you know, it should be referred to as such, because that is a way in which describes sufficiently the kind of violation of consent that takes place by sharing someone's image without their consent. And you know, it's a term which kind of allows for an understanding of this offence as a form of violence, which it is. So one of the issues with the kind of attitude around image-based sexual abuse is the fact that it's often referred to as revenge pornography. And the problem with that is that it implies a portion of blame on the part of the victim. And the reason it does that is because by you know, attaching the term revenge to it, kind of suggests that the victim must have done something, you know, to kind of warrant their image being shared without their consent, to warrant the offence taking place against them. It almost kind of partly justifies what the offender has done when there is no justification for it, really. And many people who have argued against using the term revenge porn have kind of made the point, the very valid point, that we don't attach the term revenge, you know, to any other offence in law or criminology. There's no such thing as revenge murder, for example, or revenge, you know, robbery. It's just robbery and it's just murder. So, you know, essentially there's no justification or excuse for the offender doing what they do in those circumstances. And it should be the same, you know, kind of principle when it comes to image-based sexual abuse. So that's one of the kind of first issues with this topic, and using the term revenge porn and kind of putting or suggesting to put a little bit of the blame on the victim does nothing really to kind of help the long-term issue of a real lack of willingness to report on behalf of victims, to report any kind of sexual offence, not just image sharing, and you know, the obvious reasons that they don't tend to report a sexual offence, you know, the stigma that's attached to reporting that, you know, having people in your kind of local area know what's happened, and know that, you know, you carry that sort of, you know, stereotypical shame with you, and also the kind of the kind of battle of, you know, if you do decide to report what's happened, it's not even just as simple as that. It you know, there's a lot more steps to go through. It has to lead to an arrest, and then lead to a prosecution, and then lead to a conviction. So there's a lot of steps to go before your reporting of the offence actually gets to the point you wanted to get to legally. So, you know, calling it revenge porn and attaching that kind of the term of revenge to it doesn't really help with those issues, those reasons for not reporting the majority of sexual offences. And like I said, you know, image-based sexual abuse, only calling it what it is, really kind of allows for an understanding of how much of a violation of consent it is. So I mentioned at the beginning the Harassment, Harmful Communications and Related Offences Bill, which was only passed last month by the Minister for Justice, Helen McEntee. It took a long time to go through, before it was passed. It was actually proposed first in 2017 by the Labour Party. And it took, a lot of kind of campaigning by victims, and also some high-profile cases, for it to finally go through and be signed into law. So a couple of the high-profile cases which kind of highlighted the problem of image-based sexual abuse in this country were one, the case of Nicole Fox Fenelon, and the bill is actually kind of also known as Coco's Law, which comes from Nicole Fox Fenelon, whose nickname was Coco. She took her life after a kind of an onslaught of online abuse. Another case was Dara Quigley, I think the year before in 2017, who also took her life after naked images of her on CCTV were shared by a member of An Garda Síochána. So those were two kind of huge cases which caught a lot of attention in the media, and raised kind of a lot of awareness of the impact of image-based sexual abuse for a lot of people who until that point wouldn't have realized that it was even, an issue to begin with, or certainly wouldn't have realized that, the kind of impact that it has on victims. But even beyond those cases in 2017 and 18, it really took a kind of a large-scale social media campaign in July 2020 to really kind of force the government to take action. And it was a petition that was created and signed over 10,000 times, which was the kind of last straw, and which really made the government push through Coco's Law. And that petition and that kind of campaigning on social media came after a kind of somewhat famous case of a platform or a database called Discord, where thousands of images were shared non-consensually by a group of around, I think, 500 men. And the fact that that impacted so many victims at the same time is kind of partly what made the issue so kind of pressing, and like I said, forced the government to kind of take the action that they did last month. So speaking of the bill, it's kind of, obviously a good progression in terms of the law to protect victims and also to punish offenders. So under the Harmful Communications Bill, any offenders who are found guilty could face a custodial sentence of somewhere between 6 months and 7 years, or face a fine of up to a maximum of £5,000. So most offenders, I would imagine, would fall on the kind of shorter end of that in terms of serving a short sentence or receiving a fine instead of a custodial sentence. But it is progressive in terms of, it's more than would have happened before. Legally it wasn't even an offence up until now. So it kind of extends that protection to victims, and given the fact that it's so recent, I think a lot of victims will kind of feel that it's, too late in their case, victims who have been who have had their images shared non-consensually before now, but it will at least serve to kind of protect potential future victims. And kind of amazingly, up until now, up until this bill had passed, there was no legal protection, like I said, for victims. Only those under 18, so those who are minors, were protected against the non-consensual sharing of their image. That was under the Child Trafficking and Pornography Act 1998. but there was no such protection for those over 18, which is kind of stunning, really. So, and although it kind of extends that protection to victims, this new bill, there are still some kind of issues with it that you know, some people have kind of pointed out, that it's not, that, you know, the legislation is not you know, airtight, or not as kind of strong, you know, legally as it could be. One of the main issues with it is, you know, if you look at section 2.2 of the bill, it requires that the sharing of an image without the victim's consent, it requires that sharing of the image really disturbs the person's peace and privacy, or that it causes them serious alarm or distress. So what that does, in effect, is kind of place the burden of proof on the victim. It at least partly does that. So that goes back to what I was saying at the beginning, where there's an element of kind of almost victim blaming again, where if a victim of image-based sexual abuse takes their case to court, they would essentially have to prove that by sharing my image without consent, that person caused me serious alarm or distress, or, you know, really disturbed my peace and privacy. So putting that burden of proof on the victim really it more so discourages the reporting of offences more than it encourages reporting of offences. It's difficult anyway to achieve a conviction for a sexual offence without further kind of burdening the victim with, you know, the necessity of proof on their part. So that was kind of one of the main issues with the bills. Although it does, you know, afford victims more protection than they've been afforded up until this point in terms of image-based sexual abuse, it's still there's still a little bit of a gap in the legislation, which could, you know, potentially be filled later on, you know, which could cause some problems going forward. So it all really comes back to kind of, you know, pointing the finger at the victim, and, you know, not believing them, or believing that they're exaggerating their case. All of those sorts of issues are associated with sexual offending in general, and, you know, not specific to image-based sexual abuse. They're all kind of related to sexual offending in general. So really, as far as a lot of people are concerned, those issues come back to a kind of need for education on consent, sort of educational reform in Irish schools, which are kind of held back essentially by the sort of influence of the Catholic Church in terms of their kind of watering down of any kind of sexual education for young students. You know, any kind of campaigns or any kind of attempt at educational reform up to now has really been held back by the fact that schools will argue that that a more open sexual education is against their ethos as a school, which is run or at least influenced by the Catholic Church, and most schools are in this country. So these issues of breach of consent, and of a kind of a lack of understanding of why, for example, sharing someone's image without their consent is wrong, and the impact that would have on a victim, and why it has that impact on the victim, can at least partly be traced back to a lack of education on the subject of kind of respect for consent, and an appreciation of consent for both males and females at secondary school level. So to kind of put that expectation on schools, and to, you know, open young students up to that, to teaching of consent and the impact of a breach of consent, that would kind of potentially reduce the number of future victims and future offenders, because it's also it's as much as it's about protecting victims, it's also about reducing the number of offenders. I think everyone would be happy to have fewer younger people become embroiled in the criminal justice system due to a simple lack of education, lack of awareness as to what they're doing, lack of awareness of the impact of what they do on the victim. Not to excuse again what offenders do, but many cases can be traced back to a lack of education. For example, the committee appointed to monitor the effectiveness of the Garda Youth Diversion Programme, they produced their annual report in 2017, which found that there were 59 cases of possession of child pornography, and of those 59, 20 of those were actually the consensual sharing of an image from one person to another, one peer to another, before the person receiving the image then shared it, more widely to a group of friends or to their social media or whatever the case was. Those 20 people would, or the majority of them would have been, just as shocked as anyone when they found out that that was actually an offence what they were doing, and that it was a breach of consent. It's likely that most of those 20, if not all of them, wouldn't have shared that person's image had they known that it was actually an offence, and had they known that that was, not the right thing to do. So again, it's about kind of teaching young people about consent, about the impact it has on a victim when it's breached, specifically for the sharing of images, but also more generally for sexual offending. So that is it from me. I just want to say a quick thank you to Trinity FLAC for giving me the opportunity to do this talk and be a part of this event, and thanks very much for listening.